name is Antonina Burlachenko, and today I would like to update you on European AI Act timeline. Before we start, I would like just to remind you what is AI Act. So AI Act is a regulation which regulates AI-enabled systems in European Union. It is intended to ensure that we approach AI systems development in a responsible manner to ensure trustworthiness, transparency, protection of health, safety, and fundamental human rights of the European citizens. So this regulation lays down a set of rules which has to be followed before placing different types of AI systems on the European market. It also introduces categorization of AI systems. Some of the AI practices are prohibited in Europe, and then some others are considered high-risk AI use cases. So for them, we have to make sure that we follow certain rules before we place them on the market. Yet for others, it introduces transparency obligations or voluntarily code of conduct practice, and then it also introduces harmonized rules for general-purpose AI models. Besides that, it brings up different economic operator roles and obligations related to those roles. And then, last but not least, it also introduces measures related to support of innovation, such as AI sandboxes, especially for SMEs and startups. So whom it applies to? It applies to any provider of AI system that is being placed or put on the market in the European Union. So providers could be either local European providers or they could be coming from third countries. It also relates to product manufacturers that are placing their products on the European market, and those products are placed on the market along with AI systems, together with AI systems. It also applies to deployers who deploy ready AI systems as part of their kind of business operations. And those deployers may be established in Europe or in the third country, as long as their systems, deployed systems, affect and output is produced. Output which is produced by the system is used within European Union. They also have to follow their obligations. And then certain obligations are also relevant for other roles such as importers, distributors, and authorized representatives. Now let's have a look at the timeline. So part of this timeline, there's like a quick refreshment what happened, and part of it is what's coming next and what are the key upcoming milestones. So first of all, the AI Act came into force back in August 2024, and then half a year later, in February 2025, first chunk of obligations and requirements started being applicable. First of all, it's prohibited AI systems, prohibited AI practices. So certain AI practices are not allowed in European Union, such as categorization of personas or manipulation of specific subgroups, distorting their behavior. We can dive deeper into those practices some other time. Now let's proceed. So another obligation starting that period is so-called AI literacy. So any company in the European Union is supposed to ensure AI literacy among their employees. And this AI literacy obviously depends on the role the person performs and the responsibilities that a specific person carries. The next milestone was August 2025, when governance rules were rolled out, and then obligations for general-purpose AI models came in force. Besides that, notified body designation happened, and then penalty provisions started being applicable. So that was last year. This year actually brought major changes and shift in the AI Act. Specifically, it happened like final kind of step of that change happened in the end of July 2026, when so-called Digital Omnibus on AI was published in the official journal of European Union. And these Digital Omnibus introduced certain changes related to European AI Act rollout timeline. So in early August this year, 2026, transparency obligations came into force. So those transparency obligations are related specifically for disclosure of chatbots, and then also for labeling of AI-generated content. Small note should be added here is that if your AI system was placed on the market before 2nd of August this year, then you have a grace period, and these requirements for synthetic content labeling starts being applicable to you in December 2026. Besides that, in December 2026, ban on non-consensual, intimate, and deepfake content also comes in force. The next very major milestone is December 2027. So starting that month, standalone high-risk AI systems requirements start being applicable. So those are specific high-risk AI use cases that are listed as in Annex III of AI Act. As an example of this high-risk AI system use case, it could be AI systems used in the educational setup, in the employment setup, for example, to decide on the performance of your employees. Also, AI systems used for the management of the critical infrastructure. And the last but definitely not least is August 2028. On that milestone, high-risk AI systems that are embedded in the regulated products will also start being regulated. So those are the products which are already regulated by any of the regulations listed in Annex I of the AI Act. And starting August 2028, they will also have a bunch of certain requirements coming from AI Act being applicable to them. An example of this kind of system is an AI-enabled medical device, which is already now regulated by European medical device regulation, but the CE marking process will be a little bit kind of changed because some subset of AI Act requirements will come in force. So this is the timeline updates, and thank you for your time. See you next time when we will discuss in more detail different obligations for different kinds of economic operators. Thank you.